Welcome back to I Rest My Case, a new podcast series with me, Jonathan Goldberg, King's Counsel.
And me, Dean Strang, criminal defense lawyer and law professor in the United States.
And let us remind our listeners briefly who we are and what this podcast is about. I am a very experienced trial lawyer in the United Kingdom, and Dean is a very experienced criminal trial lawyer equally in the United States, practicing mainly from Madison in Wisconsin. That's where he keeps his office. And we discuss in this podcast a number of famous legal trials, and we dissect them, we consider what was at stake, the consequences not only for those involved, but for our societies, because these were all cases that raised important social issues. And we try to pull back the curtain on these trials and shed some light for you on the how, not just the why, of the criminal justice system. And we try to dispel some of the mystique that our profession likes to cloak trials in. So today we're going to deal with the famous Oscar-winning actor Kevin Spacey, who's had all sorts of legal trials and tribulations. Dean, do you want to tell us something about those?
Sure, absolutely. Kevin Spacey's legal problems began in 2017 and have resulted to date in 3 trials, 2 that have happened, 1 still to happen. Of these 3 cases, 1 has been criminal with a number of counts included in that 1 criminal case. 2 have been civil. And as I say, 1 of those civil cases still is to be tried. They've occurred on both sides of the ocean, in the United Kingdom and the United States. The first allegations against Kevin Spacey arose in 2017 from an actor named Anthony Rapp. He claimed sexual advances by Spacey dating back more than 30 years at the time that Mr. Rapp made the allegations in 2017. Rapp said that when he was 14 and working on a set with Kevin Spacey back in 1986, Spacey had made inappropriate, harassing, and sexually aggressive attacks on him. That resulted in a civil case that Anthony Rapp filed here in the United States.
So just stopping there, Rapp was looking for money. He wasn't looking for criminal prosecution and imprisonment.
Yes, I don't know what Mr. Rapp really wanted, but at least the remedy he was able to pursue, as opposed to a public prosecutor pursuing, the remedy Anthony Rapp pursued was, yes, money damages for what he alleged Spacey had done to him as a boy back in the mid-1980s. After Rapp's allegations, a number of other men came out to make similar, not identical, but similar claims of sexual misconduct by Spacey. The commonality in these allegations has been that the complainants were either boys or very young men at the time, that they were involved in some way in the film industry or theater, and that Spacey used his superior position and age to manipulate or treat them with gross indecency and in a grossly inappropriate way. The specific allegations vary, but they all concern sexual misconduct involving boys or young men at a time when Spacey himself was well into adulthood and a famed actor.
Now, by my count, Mr. Spacey is either extremely unlucky, or it has to be said he has to have been extremely promiscuous, because I've counted something like 60 or 70 men have made allegations against him, if we add it all up, and it may indeed be more. So we're really dealing in a sort of Epstein, let alone Harvey Weinstein, kind of territory of an enormous number of complainants, are we not?
We are, but I wouldn't draw a direct connection to a Jeffrey Epstein, at least by matter of degree. And I say that because the claims against Spacey, although they've been in many, have really come down to 2 civil complainants, 2 people who taken their case to court on a civil claim for money, and then the collection of 9 criminal charges in the UK, which were tried. All of these allegations were old in a sense. They weren't made contemporaneously or anything close to that, which in and of itself doesn't tell us anything about their veracity. But they were old and therefore both difficult to prove necessarily and difficult to disprove because of the passage of time.
Now, the ordinary man in the street might say, how can you possibly bring a trial for a sexual event that happened 30, 40, 50 years ago? How can there be a fair trial? And yet you and I know that what we call historic sex trials are more and more common nowadays, are they not?
Yes, limitation periods, what people often call statutes of limitations, the passage of time between the alleged event and the filing of the civil claim or the filing of a criminal charge, that has been relaxed in recent decades in the United States, and I believe also in the United Kingdom. Now, in the States, precisely because most criminal and civil litigation occurs in state court, not under federal law and federal court, in the States, it's a real patchwork of when these limitation periods have been extended or relaxed, where they've been extended or relaxed, and where they have not been. So some of the claims have been against Kevin Spacey. Some of them have been time barred. Others have not been time barred. Some of them, I think, that haven't resulted in a civil or criminal lawsuit probably would be time barred. And that may explain why there's no legal remedy to pursue.
And it may surprise people to know that here in the United Kingdom, our rule is really far simpler. There's no such thing as a statute of limitation on crime. I'm speaking of serious crime. I mean, trivial matters like traffic. Yes, they have a 6-month limitation normally. But any serious, substantial crime, in fact, any crime, even a burglary, but certainly rapes and murders, no limitation whatever.
Interesting. That's fascinating. And I didn't know that, Jonathan.
People don't. People don't. And let me tell you, I myself have defended sex cases where the allegations were 60 years old. Can you believe it? A grandfather, and years later, the granddaughter was brave enough to come forward. And an old woman herself now, and he was an incredibly old man. I forget the exact age, but that proceeded to trial. And indeed, he was convicted, by the way. I've had experience of murders that were 50 years old. So in this country, as I say, just no statute of limitation, and there never was for serious crime.
Just fascinating to me. And the difference here, in spite of the variation between states, I think I can say generally that in the United States with crimes, there is a statute of limitation for all but murder. For murder, they're typically, in fact, I'm not aware of any US state that has a statute of limitations on murder. That charge can be brought anytime. Essentially, any lesser offense in the United States will have a limitation period with the proviso that the limitation period doesn't run if the defendant has left the jurisdiction, has gone elsewhere, out of the reach of the arm of the law, so to speak. So functionally, if the clock was stopped while you were out of the state or out of the country, yes, sometimes we do have criminal prosecutions that are 10, 20, 30 years after the fact, but it's not the norm.
Yes. So let's come to the question that I think a lay person would automatically ask. He would say, well, how can you possibly have a fair trial of something that might be 50, 60 years old, let alone 30, 40 years old, as is the case with some of the allegations against Mr. Spacey? How can you have a fair trial? Now, I would argue, actually, you can. But let me ask you first, do you think you can?
I think that's really troublesome. I really do. And you're balancing, a need to pursue justice if we assume guilt or, civil liability, a need to pursue justice for a long evaded injustice, long unpunished misconduct, against the possibility of innocence, or that it just didn't happen at least the way the complainant says. And the problem with defending a case like that is that, if you had witnesses who said, well, we were out for pizza that night, they don't remember that 30 years later. Your diary, as you might say, or the calendar, desk calendar, as we tend to say here, those have disappeared after 10, 15, 20 years usually. Memories have faded. All possibility of documenting where you were, even with modern technology, cell phone records, that kind of thing, normally is lost as a matter of time. Now, that also hampers prosecution of these crimes or the civil plaintiff. The civil plaintiff will face some of the same problems in proving events that, allegedly occurred 31 years earlier in Mr. Rapp's case, for example. So I'm not sure that the burdens fall unequally here. It's just hard to try a case where the events are decades old. If it's a criminal case, of course, liberty is at stake for the accused. And one might say there's reason to be more concerned about the burdens in defending yourself in that regard. On the other hand, if you did it, then you've enjoyed 3 decades, 2 decades, whatever it is, of unaccountability for what you did. And in that respect, it probably bears mentioning that in the United States, some of the impetus for relaxing or extending these limitation periods, especially in sexual misconduct cases, came from the scandal in the Roman Catholic Church with abuse of choir boys, altar boys, girls, children, young adults by priests, alleged and actual. And that unfolding scandal, beginning in the 1980s, led to a lot of pressure to not bar these prosecutions or civil claims simply because of the passage of time.
When I say that I think you can have a fair trial, I think I need to explain myself a little more fully. Now, the attitude of our judges, if I go back something like 30 years, and I remember it very well from practicing them myself, you would run before the judge, before a jury criminal trial started, an argument called abuse of process. And you would say, Judge, this is an abuse of process. It's not fair for you to let it go to the jury at all. Stop it now, because it's so old that nobody can possibly remember, and people must be speculating, and there's no supporting evidence. It's just his word against her word, or vice versa. And very often the judge would say, I'm with you, Mr. Goldberg, it ends here. But then our Court of Appeal and various of our Lords Chief Justice, they changed the attitude entirely. When the cases reached them, they said, no, this is why we have juries. Juries are common sense bodies. You address them about the passage of time. You address them about the dangers of wrongful conviction. Leave it to their good sense. And we, as judges, will at least direct them that they've got to take into account the passage of time and the way it may have made it very hard for a defendant to defend himself. And equally, the way it may have made it very hard for a genuine complainant to make her case credibly, or his case credibly. So our attitude today is no limitations. You leave it to the jury, and Bob's your uncle, essentially. I think I'm in favor of that because it is an affront to justice. For example, let me just give an obvious example. The tremendous advances that have taken place in DNA evidence, which just didn't exist a generation ago. And they're reinvestigating, other police forces, all these old cases called cold cases. And sometimes they come up with a stain on a swab that's lain in the exhibits box for 60 years. And what do you know? They examine it with the benefit of modern science, and they can prove a murder was committed. They can link it to the defendant, even though he's an old man today. And there have been many such cases in the United Kingdom, and you will, of course, have had them in America too. So why should these people get away with it? That's my attitude. Why should there be? It's unfair to the victims. It's unfair to society.
Well, it is if we presuppose that there is a victim. Now, and of course, in a murder case, we know there's a victim. That, unless there's a body never found, we know there's a victim in a murder case. And I think that is different. with other cases where the essence of it rides on an accusation. If you assume the accusation true, then of course it's a great injustice and better to cure it late than never at all. If you assume instead innocence, or at least the possibility of innocence, then all of the rightful concerns that I've raised, witnesses dying, memories fading or disappearing altogether, loss of documentary evidence, all of those become real concerns, to anybody who wants to try to get a case right, at least as right as the burden of persuasion will allow us to do. So I do think it's a very difficult problem because there's no gainsaying the fact that if it happened, it ought to be remedied. There ought to be some effort to rectify it if it happened. And likewise, there's no gainsaying the fact that if it didn't happen, if it's a false accusation or a product of memory that has changed over time, then innocence ought not be punished. I sort of like the English approach of having a bit of a safety valve for abusive process, as you describe it. And I'm also with judges who say, look, let a jury sort it out. We'll tell them that passage of time bears on this, may affect both sides, but trust juries in the end. I'm with that approach philosophically, and I might add that's basically the U.S. approach, both as judicial philosophy and our statutes. Unless a limitations period bars it, ordinarily you cannot foreclose a civil claim or a criminal prosecution if commenced within the limitation period, just on the difficulty of defending. Ordinarily, you can't do that. So I think English and U.S. courts sound to me very much in the same place now.
And of course, we're talking about the area of sexual relationships. And as we know, there's no area of life that's more sensitive, more nuanced, where psychology comes into it more, where all sorts of difference of perception. He thinks she is consenting, she wasn't, but did he realize? All this sort of thing comes into it. So it's a terribly sensitive area, even at the very best of times, even for an alleged rape or a sexual assault that happened last week, let alone one that allegedly happened 50, 60 years ago, as occasionally is prosecuted in the United Kingdom today.
Well, and look, I mean, this probably bears saying for those who aren't lawyers. Take Anthony Rapp's case. He makes the allegations in 2017. They relate back to 1986 when he was 14. So by the time he makes these in 2017, he's roughly a 45-year-old man, not a 14-year-old boy anymore. By the time they're tried in 2022, I think he's another 5 years older. He's essentially a 50-year-old man. And the incalculable thing about this is that the jury is looking at a 50-year-old man on the witness stand, not at a 14-year-old boy or a 15-year-old boy. If the case had been brought very quickly after the alleged events. Now, jurors can try to project back and try to imagine what a 14-year-old would have perceived and what the accuracy or inaccuracy of that might have been. But each side is encumbered, in a sense, by trying the case today in present time and trying to project backward to a time when both the plaintiff and the defendant were 3+ decades younger.
Well, my attitude, and as I say, the attitude of the English criminal courts today is leave it to the jury. It's the only system we've got. It's the best we've got. Until I suppose, I often think that the days are going to come and cannot be too far away when artificial intelligence invents such an accurate lie detector that you and I will be out of a job, but it hasn't come yet quite.
No, and I have no confidence that ever will come, but I could be wrong. I too am a believer in the jury, perhaps because it's been instilled in me since I was a kid, before I even started law school, growing up in the culture I have and that you have. On the other hand, the more I explain a well-functioning, procedurally sound inquisitorial system, as in France, for example, the more appealing in many respects that approach to truth-finding looks. The less it seems to ride on adversarial incentives and the lawyer's desire to win, either as prosecutor or plaintiff's counsel or as defense counsel in either a criminal or civil case. It seems to me, when well functioning, really geared toward seeking truth as opposed to seeking a winner and a loser. And I might say that maybe with no connection at all, criminal penalties tend to be quite a bit lighter in France and many of the continental systems that use this inquisitorial rather than our adversarial model, and don't use lay juries in these other countries. I can't get away from this inborn preference for letting citizens have a role in the administration of justice, a really robust role, by serving as jurors. Now, in part, I'm undercut there by the paucity of jury trials that we actually have in the United States. Fewer than 5% of criminal cases go to a jury trial, probably fewer than 3% of civil cases.
Actually, just the same in the United Kingdom. But let me come to a particular problem that I identify here, and I'd like to know your views on it. Despite the many dozens of accusers that are out there and have come forward against Mr. Spacey, as you and I know, the fact is he's been a lucky man because he's only faced to date 2 trials.
And he's won them both.
And he's won them both. And the first, as you say, was the trial for money of Mr. Anthony Rapp. He wanted 40 million or something like that. He got a bill of $40,000 he had to pay himself for his legal costs, and that's all he won. And then, of course, more seriously for Spacey, he was accused by 4 particular men in the British trial at the Southwark Crown Court, a place I've often practiced. And he was accused of sexual assault by 4 different men on 9 total counts. And he won that resoundingly as well. The jury acquitted him resoundingly. So he's been very lucky. And there's one trial possibly in the pipelines in London, which is again a civil trial only, an actor called Rory Cannon, who alleges assault many, many years ago when he was a youngster. And that trial may or may not happen because, of course, it's very expensive to bring a civil trial in Britain, and whether Mr. Cannon has the resources to see it through, we'll have to wait and see. It's in its very early stages. There aren't even yet formal pleadings yet. So that may never happen, actually.
But you raise an interesting point, which is the matter of wealth or its absence.
Oh, yes.
At least in 2017, I think we safely can assume that Kevin Spacey was a wealthy man compared to most of us. That wealth certainly has been diminished.
Well, he's had to sell his house.
Had to sell his house, and much of his wealth, in effect, has been transferred to his lawyers over the course of the defense in the various cases. But he's had the basic resources to defend himself.
Thus far. But of course, Netflix are suing him. Indeed, let me be accurate. They have a judgment against him for no less than $31 million because they had to sack him from House of Cards prematurely for messing around allegedly with other actors on set. And it's because they had to pull the plug on the series effectively. They've given him the bill, and the judge has found in their favor. So the poor fellow, however you look at it, I think he is now destitute and on his uppers. But the question I was coming to, Dean, and I would like your thoughts about, was this. This man is, in my view, the greatest actor I've ever seen. I've seen him on the stage. Of course, I've seen him in cinema, as we all have. I tell you, I remember a performance of Richard III in London that will stay with me all my life. He was more Richard III than Richard III was. So he's such a consummate, brilliant actor, which probably means he's a very mixed up fellow in his own psychology and internally. But let's not go there for the moment. And of course, well, I say let's not go there, but his own brother has gone on television saying the father was a monster who sexually abused his elder brother grossly, and who was a Nazi and a ghastly person anyway. So whatever his demons are, one can safely assume Kevin Spacey has tremendous demons, which is probably what has made him the great actor he is. But my question, given that this is one of the great actors, if not the greatest actor of the world, and he's given evidence twice. He gave evidence to the New York jury, which dismissed Rapp's civil suit, and he gave evidence to the Southwark Crown Court over several days, and the jury were eating out of his hand by all accounts in that case, and they acquitted him. How can a man who's such a consummate actor, how can you ever fathom the truth of the evidence he's giving? That's my question with a rather long lead up.
Well, back to our shared faith in juries. Fooling all 12 people with the common sense they bring to the jury box is a tall order for anyone. I'm sure it can be done, to the detriment of justice, no matter which way a jury gets the verdict wrong, if we knew that omnisciently. But it's a tall order to fool 12 people. And I thought maybe you were going to drive at something different, which is a great difficulty that I think we have socially today, manifest in the social media sphere in which many of us seem to spend most of our time. And that is holding two or more things that are true in our heads at the same time. The fact that a man is an enormously talented actor, or someone is enormously talented, gifted, and praiseworthy in some other walk of life, can be true at the same time as them having done something terrible, them having a dark side, or having committed acts that are inexcusable and horrible, manipulative or destructive to other people. These things both can be true, and I think often are. I'm not commenting on Kevin Spacey in particular, but the idea that one has to be one or the other is just something we increasingly seem unable to grasp. To say nothing of the third, the additional facts. A monstrous father who may well have hurt Kevin Spacey, almost certainly did in one way or the other through the course of his upbringing. And you run into the reality that hurt people, as they say, often then hurt people. But we seem often unable to grasp the fact that we are not dealing with monsters and heroes. We are dealing with human beings all the time. You and I know that from our work. We often like clients who are committed of the most, or, accused of the most horrendous things. We often dislike clients who are accused of relatively minor offenses or, trivial matters. We see a human reality that, for whatever reason, often seems to escape popular culture.
Yes, humans are very complicated animals. I remember one client of mine who was a professional armed robber, and I've no doubt that if you'd stood in his way as a bank cashier, he would have shot you, probably in the leg first, and only then if he had to somewhere more important. But I remember that guy had the best sense of humor I have ever encountered in another human being. He was a pleasure to talk to, and yet I was always conscious, obviously, of his very evil side. But we as criminal lawyers, we have so many such experiences which we could relate, don't we?
We do. All of us do, if you've been at it for more than a year or two.
Indeed.
And I want to go back, if we can, here because I brought up social media and popular culture. In 2017, Jonathan, when Anthony Rapp first made his allegations, Kevin Spacey initially responded, as one does these days, by tweeting, on Twitter or some other, I think it was probably Twitter at that time, some other social media platform in any event. And in doing that, in responding politely to the allegations, professing his admiration for Anthony Rapp and also professing that he had little recollection of the events, he acknowledged publicly for the first time his own sexuality.
He came out. He came out as a
He
gay
did.
man.
He did. And said he'd had intimate relationships with women and men, but that he'd chosen over time to live as a gay man. Now, one's sexual orientation, one's sexual preferences, whether you're a public figure or not, are your business, are one's own business. And he chose to make this public, and he was pilloried on social media by many people for picking that moment to announce that he was gay. I think that was unfair to him. I do, and I can explain Bible, but I want to hear your reaction to that.
Yes, I recall when you and I were researching for this podcast, reading an interview that Spacey, as I say, this man whom I personally admire so enormously as an actor, reading an article where he gave an interview in the Evening Standard of London in 1998. And he said then, I cast a complete veil of secrecy over my private life. I choose to do that, he said, unlike some actors, for the simple reason that the less you know about the real Kevin Spacey, the more you believe Richard III, for example, when you see him. And I thought that was a brilliant answer, actually. And until 2017, when he came out of the closet in this tweet, we knew nothing about his private life, unlike all these other fake celebrities where we know who their new girlfriends and boyfriends are the moment it happens, and we see photos on the beach in bikinis and all the rest of it, hand in hand. So I really respected that. But of course, if you and I had been advising him in 2017, I suspect we'd have said, don't do that tweet, Kevin, because, of course, that tweet also proved to be Mr. Rapp's main evidence against him in the civil trial that Rapp lost, because the tweet was actually very hard to construe it in any other way than it was an apology. And it even said, well, I don't remember specifically, but if it happened, and I'm not doubting your word because you're an honest man, but I can only apologize and say it was a dreadful drunken escapade on my part and I should never have done it. So really, that sounded like an apology to me. And if you're going to have to fight a future trial, that's not a sensible thing to have said at all. Later, when confronted with that tweet, of course, in the New York trial, his excuse was, my publicist made me do it. Maybe.
And that may well be true. And maybe that was poor advice from the publicist.
He should have come to you or me, Dean.
Well, and we would have advised him to say nothing.
Sure.
But on the other hand, if you indulge for the moment, just indulge the assumption for the moment that he wanted to make that statement and that he spoke sincerely. Let's just indulge that assumption.
Yes.
Maybe unwarranted, but for the sake of argument, indulge that assumption. If that's so, then it was a candid and decent thing to say. If it's true, if it was true and sincere at the time, it was an act of decency on his part to acknowledge. I have that. It was a tweet. I have it up in front of me. I'll read you the first paragraph. You've accurately cast it, but I'll read his exact words. I have a lot of respect and admiration for Anthony Rapp as an actor. I'm beyond horrified to hear his story. I honestly do not remember the encounter. It would have been over 30 years ago. But if I did behave then as he describes, I owe him the sincerest apology for what would have been deeply inappropriate drunken behavior, and I am sorry for the feelings he describes having carried with him all these years. Now, you can make lots of assumptions about insincerity, or trying to duck and bob and weave and preserve your public reputation while issuing a non-apology apology. But if that was sincere, it's an act of decency. And the second paragraph then is where he discloses his own sexuality. And again, whether you're a public figure, a celebrity or not, your sexuality is your own to decide how much you're going to let people into that, by definition, intimate area of life. And he gets pilloried as if he's looking for a pass because he's gay, or that somehow being gay is an excuse. I don't read him as saying that at all. And maybe I'm in defense mode here, defense lawyer mode. That's my default position. But look, had he said nothing at all about his sexuality in that initial response, I suppose people would have assumed, well, he's not gay. Majority of people are heterosexual, not attracted to the same sex. And you would have had a basis for assuming it's a false allegation. Why would a straight man be pursuing a 14-year-old boy? Assuming you're not, a hebephile or a pedophile or some really deviant sexual interest in any child. By acknowledging that he was gay, in a sense, he's lending some plausibility to the accusation. He's not making a denial that I would have never sexually pursued a man. That's not my polarity. He didn't say that. To the contrary, he said, I'm gay. Giving some implicit lift to the allegation itself.
Definitely.
And I don't read him as having sought a pardon because of his sexuality. I think it was an unfair claim. And I think he, as I've said, he would have been damned if he did and damned if he didn't at that point.
Yes, I couldn't agree with you more. And all these spokespeople for gay and LGBT rights who pilloried him and said this is about abuse. It's not about whether you're gay or not, and you're distracting from the issue. I thought that was very unfair as well at the time.
It's a truism. Of course, it's about abuse, not about your sexuality. But he wasn't saying it didn't happen or that, I don't deserve accountability for it.
I'm with you.
I just think I thought they were virtue signaling, it seemed to me, in a way that's unbecoming.
And I thought it was a very sincere and honorable thing for him to write as well. But the other side of the coin is that when 5 years later he came before that civil jury in New York who had to decide whether Mr. Rapp's allegations were true or not, he seems to me to be an incredibly lucky man that the jury found in his favor, because I can't read that tweet as being anything other than a candid admission.
If it was candid at all. And again, I'm making an assumption. Given Spacey's status and the coterie of publicists and agents and lawyers, we can assume were around him at the time, this may have well been a heavily managed, edited, ghost-written tweet, for all I know, whether well-advised or ill-advised.
Because he was then at the very height of his fame and prowess, and a wealthy, incredibly successful actor. We must remember that. But let me change the topic to an issue of pure law now. We have a rule in English trials now, which I find incredible and unfair. And this has been in operation for, I suppose, about the last 20 years, give or take. But in the 30 years before that, when I was busily defending alleged rapists and alleged sexual assaults and this kind of thing, and child cases, which are the most horrible of all to have to defend. But in those years, there was not such a rule. And what I'm coming to is that we now have a rule that you're not allowed to cross-examine when you defend someone on trial. You're not allowed to cross-examine the victim, or let's call that person the complainant, at all on their previous sexual experience. Now, either with other people entirely, strangers, let's say, or with the defendant himself. And I'm going to give you an example from a case that's only about a month old, and a younger colleague of mine whom you met and know, a very competent trial lawyer called Jeffrey Israel. And he was telling me about it only this morning. And what happened was this: he's defending a boyfriend who for 2 years was going out with the lady who now complains. And they ceased their friendship, and there was about a year in between. And then they met up and they had a drink, and someone suggested, why don't we try it one last time for the sake of old time's sake? And they ended up in bed. And incredibly, I better not be too technical in what I'm going to say now, but apparently the way they had always used to make love in the 2 years they were together, they'd begin with, let's call it oral sex, and they'd move on to, let's call it penetrative sex, and hope no children are listening to our podcast. And on this occasion, they began with the oral sex, and then she said no to the penetrative sex for whatever reason. And all this was agreed between the two of them, by the way. Now comes the point of disagreement. He continued to have his wicked way with penetrative sex, and she says she did not consent to that, and she later complained of rape. So, not a strong case on any view. If the jury had known they were together 2 years as boyfriend and girlfriend, and this is the case, this is the way they always used to have sex, as she would have agreed. But can you believe it? The jury were not allowed to know. So stringent is the British law that you can't cross-examine on previous sexual experience. They had to begin at the night in question and decide who's telling the truth. Well, Jeffrey is, of course, very competent, and he won the case. But by God, he was lucky to win that case, it seems to me, because the vital material is being kept away from the jury by this, what I would call, politically correct attitude now, that even a prostitute can be raped, and therefore it's not fair to ask anything about her previous sexual experience. It now has infected every case, for whether it's a man complaining, a woman complaining, it just doesn't matter, a youngster. So the jury can have the impression, for example, that this beautiful 17-year-old girl who comes wearing a white dress with daisies on and looks as though butter wouldn't melt in her mouth, the jury is not allowed to know that in point of fact, you know, she's had 3 illegitimate babies and was with the defendant in a relationship for 6 months before the alleged rape. Do you have anything like that in America?
Well, we do. It strikes a different balance, one you might prefer. But before we decide how much of an overreaction this is by the law, let's start with what it's a reaction to. All right?
Yes.
Historically, in both England and the United States, historically, rape, to be proven, required not just that the prosecution prove the woman's lack of consent, but that also the prosecution prove that she resisted to the maximal physical limits of her ability. So she had to both not consent and forcibly resist. Otherwise,
so was that the law in America? Because it's never been the law in England.
That had been at one time the law in England, and it came here. And indeed, way back in England, only a woman could be raped. I say woman because there was no such thing as rape of a boy or a man. There were other crimes that could be committed, but only a woman could be raped. It had to be without her consent, and she had to physically resist it to her utmost ability. And it's true in the United States, true essentially up until the 1980s, okay? And the defense was allowed great leeway to explore all of her sexual past, essentially to dirty up her character, including even things like how was she dressed on the evening in question?
Oh, yes.
Or was she dancing with other men on the evening in question? Or was, in other words, was she a loose and licentious woman, as if somehow she then couldn't be the victim of sexual assault, that she must have consented to have sex tonight with this dope because on 10 past occasions she consented to have sex with 10 other dopes, okay? And so it was a great illogical and unfair system where really the complainant was put on trial in many respects. We had a backlash against that developing in the 80s that was long overdue, in my view. You're trying the accused, not the complainant, and you're trying to get at the truth of whether she did or didn't consent, not how good she was at fisticuffs or at, fighting somebody off who often was much larger. Now, where we've ended up in the US, in most states, and I'll just use the federal rules as the mean, if you will, or a shorthand for where most of American law is that prior sexual conduct between the complainant and the accused is admissible for the context of their relationship, and to help assess was the consent, was the not consent. Consent now can be withdrawn at any time,
Yes.
which also fixed an earlier anomaly or unfairness of American law, that once you consented in for a penny, in for a pound, now consent can be withdrawn. Anything that came before withdrawal of consent, and to which there had been consent, of course, remains legal, not a crime. But anything continued after withdrawal of consent now becomes criminal. So what you're describing, one type of a sexual encounter moving to another type of sexual encounter, in fact, would be a crime in the United States today if it was clear that she said, no, that's enough, no more. I don't want to proceed further. That would be sex without consent from that point forward. But a jury would be allowed to consider the context of the earlier sexual relationship between those two people, not, any other sexual adventures or experiences the complaining witness may have had, but between those two people. And there's also some room in US law, Jonathan, in cases where the issue is, if the allegation by a child weren't true, how would the child have had precocious sexual knowledge? How could the child have described human sexuality or a sexual encounter if the allegation weren't true? In those situations, generally in US law, if you can point to solid evidence of an alternate source of the child's precocious knowledge, I'm talking about a young child here, precocious knowledge, that may be admissible. And then finally in the US, generally, if the complainant has a history of making false accusations of assault, those are admissible, generally in the US, if it can be established that the prior accusation was a false one.
Well, I can only then say that if I were in the unlikely position of being accused of rape, my age, I would much sooner be tried in America than in the United Kingdom, because I think the rules have become crazy against a defendant in the United Kingdom.
Do you
And
think that will shift back? Do you think they'll find an equilibrium?
No, because it's now statutory, the rule that you cannot cross-examine on previous sexual experience. But Deal, coming back to what we were saying earlier, if you're going to trust a jury to use common sense and to take into account all the relevant arguments for a 50, 60-year-old sex case, whether they can be sure or not that the thing happened at all, why should it be that you suddenly say, but of course they're stupid when it comes to her previous sexual history, and they may not realize that a woman can have been a prostitute and still be raped? It's nonsensical. Why should a judge keep things of that kind away from them? They're children for one purpose, but they're incredibly adult as judges for another. It's just illogical, isn't it?
Well, and I understand what you're saying. I can only point to a clear history of misogyny in American and English law, and that we may not have the balance right. The balance was certainly wrong in the past.
I agree the balance was wrong.
We may not have it right today.
But what on earth is the reason to have these protective rules, as though a jury can't be trusted to come to the correct conclusion with all the relevant evidence? I'm for inclusion. I say give the jury the lot and let them work it out.
And isn't this one of the problems for those of us who defend the jury system? If you're in on juries, you've got to take a lot of bad with the good, and say that on balance, I'm going to take my chances in human affairs with 12 people off the street drawn to try to make a unanimous decision in a committee room, in effect.
Let me come to another topic that arose in the Spacey trial in England. Now, he called 10 character witnesses. A character witness is, of course, somebody, and he had famous people. One of them was Elton John. Another was Elton John's husband, a man called Furnish. And he called these people basically to say, we know nothing about the allegations. We weren't in the bedroom, of course not. But he's a wonderful guy. He's helps old ladies across the street. He's kind to children, and he gives to charity and all the rest of it. And 10 of them were called. And obviously, they made a big impression on that jury. Uh, do you have this in America as well, that you call such witnesses? And have you commonly done it? I've certainly, in England, I do it whenever I can, because I find it has a disproportionately important effect on a jury. Because if they like the guy, and if they think, well, he may have done it, but he's a very nice fellow, we wouldn't want him to see in prison, you're halfway home, I find.
Well, we do and they're called character evidence today. I think the roots in this go back to very early English law, the idea of oath helpers or a compurgation, where you would call people to essentially say he's a truthful guy. I think he's a swell guy. He's unlikely to have done anything wrong. And even though they don't know anything at all about the allegations, if you go back to the 13th century, for example.
Actually, they weren't even saying he's a swell guy. They were saying, these oath helpers or compurgators, they were saying, you can believe his oath.
Yes.
Whatever he says on oath, you can believe it. Take it from me.
Exactly. Implicitly, because he's a good person of integrity and honesty, right? Well, so the modern manifestation of that has been character witnesses. And much as, there are many things wrong with U.S. criminal law, we've had a pretty self-regulating balance that's struck on character witnesses since about the mid-1940s, at least. A quite influential U.S. Supreme Court justice, and Robert H. Jackson, probably, to my mind, the most elegant writer ever yet to have sat on the United States Supreme Court.
And he was the United States prosecutor at the Nuremberg trials.
You're exactly right. He was the chief prosecutor for the United States at Nuremberg, took a break from the U.S. Supreme Court to do that at President Truman's request. Well, he wrote a decision in his marvelous way of writing in a case called Michelson against the United States. And that's still widely followed. And what he said, and the reason you get such good self-regulation now, if you have good lawyers on character witnesses, is he said, look, you can call your character witness to testify to relevant traits of character. But if you do, on cross-examination, they can be asked two types of questions. Have you heard? And did you know? And the otherwise inadmissible can be offered in evidence if it has a good faith basis through the have you heard question or the did you know question. So when the priest comes in to testify, oh, he's a wonderful parishioner, he's a good boy, he's been a great lad, he gives regularly, he's in church in the second pew every Sunday, swell fellow. When the priest comes in to testify to that, the priest then can be asked, did you know that he was convicted of shoplifting as a 13-year-old juvenile delinquent? Had you heard that he stole from his own mother? Things that didn't result in charges, things that don't bear on the current accusation, things that, as I say, may have never been the subject of adjudication or even a charge, maybe decades old. All of them are admissible under Michelson's reasoning because they, not for their truth, but they go to how well the witness actually understands your character. How well does he actually know and understand your character or your reputation in the community?
I can see the common sense of that. And in England, a defendant is much more privileged because those questions cannot be asked in an English court. And I quite see the common sense that they should be allowed.
They can in American courts. And so, have I called character witnesses? Sure. But before you do that, you have to be awfully confident that there's nothing out there like that, that the prosecutor can ask on cross-examination, which often, by the way, means trusting your client deeply.
Which is always a dangerous thing to do.
Right. Trusting that he's not hiding the most embarrassing details or details he might have forgotten from his earlier life, but that the prosecution will uncover.
The rule of thumb of a good defending lawyer is never believe your client any more than you absolutely have to, isn't it? Just a word, perhaps, because it's maybe amusing for our audience. You've described trial by compurgation. That was the Anglo-Saxon method. You just got more people for one side to say you can believe him on oath than the other side had. Of course, the next thing they had was trial by ordeal for many hundreds of years, whereby the idea was God would decide who's telling the truth. So, for example, if a woman was accused of being a witch, they'd dump her in the river. And and if she floated, that God meant she wasn't a witch. But if she drowned, there you go, she was.
Well,
how wonderful was that?
These trials by ordeal that you describe, I think, actually preceded compurgation or oath helping. And you can see the connection, right? I've got 10 people who say I can be believed, and you have only got 5. So it is trial by combat or ordeal.
And of course, the
church
sense. Were all in favor of trial by ordeal because it left it to God to decide. And then the next system they had was trial by battle, whereby if I said you were the murderer and you said you weren't, we would have a battle. And whoever won was telling the truth.
Right. And the compurgators or the oath helpers were just the bloodless way of having the same sort of battle. I'm not sure
that those systems were any less correct in their outcomes than our present trial by jury. But I'm joking.
I'd like to hope they are. Well,
we'd like to hope they are.
So here we are. The net effect of this is that Kevin Spacey was found not liable by a U.S. jury quickly, found not guilty of 9 criminal charges by a U.K. jury less quickly, but still decisively, and possibly faces 1 civil trial yet to come. His assets diminished considerably, his public profile reduced, although I will note he seems to be on the comeback trail. He won an award at Cannes, at the film festival in Cannes in May of 2025. Gave a full-throated defense of himself there, I might say. Had a film come out that he directed in August of 2025, so there may yet be a second act for Kevin Spacey.
Well, I didn't know that, and for myself, I wish him every luck because he's such an amazing talent. Well, of course, our next episode, we're going to discuss the trial, the really remarkable trial and tribulations of Oscar Wilde, that great Victorian poet and playwright and theatrical. And I will be suggesting that there are some remarkable parallels, although the cases are different by 130 years or more, that we can find some remarkable parallels between Oscar Wilde and Kevin Spacey and how both were ruined and abandoned by the establishment and society because of their sexual behavior.
Kevin Spacey's fall shows how power can protect until it can't. Next time, we step back in history to explore art, identity, and punishment with the tragic trial of Oscar Wilde. For now, I rest my case.